I think we all agree, from the level of the president down to barangay captain, public office is a public trust. In other words, public officers and employees must, at all times, be accountable to the people. In line with this, Madam Chair, with all due respect, I wish to invite the attention of the committee to the press interview of Her Excellency, Madam Vice President, in the Senate on August 22, 2024. In substance, the Vice President said, "Saan naman kayo nakakita? Constitutional body, inuutusan isubmit ang audit report. Hindi pa nga tapos." With all due respect, Madam Chair, may I request the resource speaker to comment on her intention about her statement.
Madam Vice President.
Madam Chair, again, question is not related to the 2025 Office of the Vice President budget proposal. On the issue of confidential funds, we have received audit actions regarding the confidential funds of the OVP. We have submitted our responses and we assure our full cooperation with the ongoing audit.
Honorable Luistro.
Madam Chair, in other words, this representation wished to be clarified when the Vice President made the statement. Intensyon ba ng ating Vice Presidente na ibahagi o hindi ibahagi sa publiko ang resulta ng nilalaman ng audit report patungkol sa kontrobersyal na 125 million na confidential fund? Nonetheless, Madam Chair, I understand that the Vice President already expressed her intention not to answer this question. Thus, please allow this representation to shift to the COA. May I request the COA to give his comment to this statement of the Vice President.
Ascom Juliano.
Madam Chair, pwede po pakiulit po yung question.
Okay, you may repeat
Okay,
the question. Hindi po natin isasama sa yung 5 minutes.
During the press interview of the Vice President in the Senate on August 22, 2024, she made a remarks, "Saan naman kayo nakakita? Constitutional body, inuutusan to submit fraud audit. Hindi pa nga tapos." We are requesting the COA to make their comment on this.
Madam Chair, ang sagot ko po siguro in relation dun sa subpoena kasi yung rationale po ng compliance namin sa subpoena, i-quote ko lang po yung second page po per sa sentence noong subpoena. This subpoena duces tecum is being issued in accordance with the oversight function of the House of Representatives. This order is likewise based on Section 3 of COA Circular 2013-006 dated September 2013. Ang compliance po ng COA ay dahil po ito ay in-issue po ng chairperson ng Committee on Appropriations. And under yung pong Congress, yung House of Representatives, is a body authorized by law to issue subpoena. And we cannot interpret otherwise. There is a presumption of regularity and validity do sa subpoena. We cannot unilaterally challenge the validity of the subpoena unless the court will interpret that pwede po or hindi pwede. Yun po yung amin ko. Kaya kami po, in-entrust po namin sa doon sa House of Representatives, doon sa wisdom po ng leadership, yung compliance sa documents. At ito rin yung sinasabi doon sa aming guidelines na pag may subpoena po, we have to comply.
Honorable Luistro.
In relation to your compliance with the subpoena, did you recall having received any feedback from the Office of the Vice President pertaining to the same?
Actually po, mayroon pong sulat ang Office of the Vice President sa aming chairman na yun nga po, may mga legal issues po na binabanggit. At ito po yung na-consider na rin po ng Office of the Chairperson noong nag-comply sa subpoena do sa STECOM.
Madam Chair, with that manifestation of the COA, may I request that the committee be provided with a copy of the letter? And having said so, Madam Chair, may I request for a suspension of the briefing?
Briefing suspended.
Madam Chair, without going to the letters of
Could
the
you-
communication,
Could you please first manifest what you have in your possession?
with me is a copy of the letter of the Office of the Vice President, signed by Attorney Zulekati Lopez, Undersecretary and Chief of Staff, addressed to Honorable Gamaliel A. Cordoba, Chairperson, Commission on Audit, Quezon City. This is dated August 21, 2024. Madam Chair, this is composed of 4 pages, and I lament that I do not have material time to go over this letter by the letters. Nonetheless, I wish to manifest that the substance of this letter is an opposition to the subpoena that was issued by Congress. If I may read, we are of the position that the subject subpoena should not be complied for the following reasons. If I may continue, Madam Chair,
Yes, please proceed.
among the issues that were raised, one is the violation of the principle of separation of power. Second is violation to due process. And third is the confidential nature of the fund. Madam Chair, I wish to manifest my comment to the issues that were raised in this letter. First, the principle of separation of power is not absolute. This is subject to exception. As a matter of fact, we call it the system of check and balances. And that is the very reason why the Congress has the oversight power, and that is to make sure that the laws enacted, including the appropriation laws, and to be specific, the GAA 2022, the source of the confidential fund, is properly implemented. If I may share, one of the landmark cases about oversight power is the Abacada Guro party list. There are 3 consequences of oversight power. One is congressional scrutiny. 2 is congressional investigation. And 3 is legislative supervision. With all due respect, by congressional scrutiny, without necessarily conducting an inquiry in aid of legislation, the Congress may request information and report from other branches of the government. Similarly, it can recommend and pass resolution for consideration of the agency involved. Madam Chair, with respect to the violation of due process, I humbly believe that we are all witnesses in today's hearing. We are in fact catering the right to due process. A number of the esteemed members of the House propounded questions already, but our Vice President maintained his position not to address the question concerning confidential fund. But speaking about due process, I humbly submit that notice was given. This is a budget briefing, and ample opportunity to explain was even accorded. It is my humble submission, Madam Chair, that contrary to the letter, we did not violate due process. As a matter of fact, we catered due process. Finally, Madam Chair, they raised the confidential nature of the fund. Ito po'y tanong na nais kong iwanan sa mga kapwa natin Pilipino. Granting that the nature of the fund is confidential and recognizing Memorandum Circular Number 15, 2023, relating to the privileged communication. Ang tanong po, Madam Chair, when there is notice of disallowance na nagsasabing ang 72 million out of 125 million na confidential fund ay hindi nagamit ng naaayon sa Joint Circular Number 15-01. And as a matter of fact, ipinababalik ng COA sa pamahalaan. Ang tanong, confidential fund pa po ba ang tawag dito? Privileged communication pa din po ba ang saklaw nito? Oo po, at tatahimik na lang po ba ang Kongreso? I wish to share the case of Chavez versus Public Estates Authority.
Kindly wrap up.
This is the right of the people to information on matters of public concern. There is no argument ang pera ng gobyerno ay pera ng taong bayan. Unless the citizens have proper information, we cannot fulfill the constitutional mandate that public office is a public trust. I submit, Madam Chair.
Madam Vice President, do you care to comment?
Yes, Madam Chair, nasabi kanina, ang gist lang na nakuha ko na nasabi kanina ni Representative Luistro, yes, is that wala siyang time na isa-isahin per letter yung letter namin sa Commission on Audit on why the requested documents should not be released to Congress. Pero nakahanda na yung mga sagot niya sa lahat ng arguments namin sa national security, sa due process, and sa separation of powers. Is this part ba of what you said earlier, Representative Kimbo, let's stick to the plan? Yun yung narinig ko sa iyo kanina na hindi mo in-accommodate yung point of order na question. And to answer, the Office of the Vice President, On the issue of confidential funds, we have received audit actions regarding confidential funds of the OVP. We have submitted our responses and we assure our full cooperation with the ongoing and unfinished audit. We are cooperating and answering all the questions in the proper venue that is inside the Commission on Audit, not in the budget hearing for the 2025 proposal of the OVP budget. Thank you.
Thank you. Note all your comments. I do not recall saying the phrase, stick to the plan, Madam Vice President. And so yes, we do note your comments, and also I believe your compliment of the brilliance of the Honorable Luistro. So
Madam
next
Chair?
to, yes.
Madam Chair, may I request that the Secretariat read your stick to the plan line?
As I said, Madam Vice President, pasensya na po, we don't have the right to make requests at this point in time. So we proceed to our next member, the Honorable Ramon Gutierrez.
Thank you, Madam Chair. Good afternoon po sa ating lahat. And to begin, Madam Chair, actually may line of questioning po tayo, but
I understand, Mr. Chair, that the statement of Attorney Roque, he was never consulted by Lucky South 99, but he has been repeating a while ago that Cassandra Leong is the representative of Lucky South 99. Is it not that the consultations made by Representative Ong with Attorney Roque, the consultations as well that was made by Lucky South 99 with Attorney Roque, Mr. Chair? So I wish to ask once more for the record. With all due respect, kayo po ba ay abogado ng Lucky South 99?
Hindi po, wala po akong attorney-client relationship sa kahit sino na shareholder or officer ng Lucky Star.
From that
Lucky South.
answer of Attorney Roque, Mr. Chair, I wish to share to the committee the case of Eusebio Sison versus Attorney Lourdes Dumlao. This is AC number 11959. April 28, 2021. If I may quote, a lawyer-client relationship is established when lawyers consistently manifest to a person consulting them that they would provide legal representation or assistance, regardless of the close ties between the parties or the lack of written contract or the non-payment of legal fees. It is very clear, Mr. Chair, that from the definition of a lawyer-client relationship, kahit walang kontrata, kahit walang payment of legal fees, the moment the client starts seeking advice and the lawyer starts giving advice, a client-attorney relationship is created. Can we be enlightened on this, Mr. Chair, from Attorney Roque?
Attorney Roque, you are now recognized.
Mr. Chair, tama po yun. Ang problema, wala pong kahit anong konsulta na nangyari sa panig ko at sa kahit kanino sa panig po ng Lucky South. Kaya miski wala pong bayad, wala pong kontrata, wala rin po kaming komunikasyon. Dahil ang komunikasyon ko po, lahat po yan ay kikasi Ong lamang.
I understand, Mr. Chair, that the statement of Attorney Roque, he was never consulted by Lucky South 99, but he has been repeating a while ago that Cassandra Leong is the representative of Lucky South 99. Is it not that the consultations made by Representative Ong with Attorney Roque, the consultations as well that was made by Lucky South 99 with Attorney Roque, Mr. Chair?
Mr. Chair, gaya na aking sinabi po kanina, Ang aking attorney-client relationship ay kay Cassandra Ong at kay Whirlwind dahil sila po ay umakto bilang ahente ng Lucky South pero hindi ko po naging kliyente ang Lucky South. Para po siguro malinaw, it is an instance where both Whirlwind and Lucky South will benefit kung magtutuloy ang negosyo ng Lucky South. Kasi kung wala naman po Lucky South, useless yung pinatayong premises ng Whirlwind. At kung wala naman ang Whirlwind, wala ring uupahan ang Lucky South. Pero pagdating po sa attorney-client relationship, dapat meron man lang komunikasyon sa panig ng abogado at ng kliyente whether or not there is a written agreement, whether or not there is bayad. Pero wala po talagang ganon dahil limited lang ako kay Cassie Ong.
Mr. Chair, I just wish to remind our resource speaker that I think there were 3 members of the committee who have been delving on this question, and repeatedly, Attorney Roque stated that he is lawyering for Cassandra Ong. Cassandra Ong is the representative of Lucky South 99. And it is really hard to conceive how he can separate himself from Lucky South 99 if his client is representing no less than Lucky South 99. Lucky South is not a natural person. It is a juridical person. The only way to talk with a lawyer is through a representative, and that is Cassandra Ong. If I may add, Mr. Chair, under Section 3 of Canon 3, lawyer-client relationship. A lawyer-client relationship, yes, Attorney Roque is correct, the highest fiduciary character. As a trust relation, it is essential that the engagement is founded on the confidence reposed by the client on the lawyer. Therefore, a lawyer-client relationship shall arise when the client consciously, voluntarily, and in good faith vests a lawyer with the client's confidence for the purpose of rendering legal services such as providing legal advice, representation, and the lawyer, whether expressly or impliedly, agrees to render such services. There are 2 elements, Mr. Chair. The first element is that the client solicits advice and service of the lawyer. And the second element, the lawyer renders service and advice to the client. I think in the given situation, both were fulfilled. There is Cassandra Ong, or there was Cassandra Ong, representing the juridical person Lucky South 99, who solicited the advice, the service of Attorney Harry Roque. And Attorney Harry Roque physically accompanied Cassandra Ong to PAGCOR, a manifestation of his act of rendering service and advice to his client. I humbly submit, Mr. Chair, that I think there are sufficient legal provisions to establish that a lawyer-client relationship was indeed created with Lucky South 99. Mr. Chair.
You want to reply on that, former Secretary Roque?
Mr. Chair, I can only say that as a lawyer, I have a different opinion. I acknowledge that there is lawyer-client relationship between me and Cassie Ong as representative of Whirlwind, who in turn acted as agent for Lucky South. But that does not mean that Lucky South gave me their trust and confidence to represent me, and I will repeat it. Kung kukunin po nila ako to quash the raid on their property, I will readily accept it. Pero yun nga po, hindi nila gagawin yun. Dahil sa tingin nila, ang kritiko ng gobyerno, hindi magpapanalo ng kaso sa kanila, magpapalala pa. Yun lang po ang sitwasyon talaga.
Mr. Chair, earlier, Attorney Roque likewise stated that Whirlwind is the agent of Lucky South. Does our resource speaker confirm this, Mr. Chair?
Yes po.
And can agency be implied?
Well, it can be implied, but an agency once delegated cannot be further delegated. Yun po ang rule.
Can it be done verbally?
Well, agency is written or verbal. Pero ang sinasabi ko nga po, yung delegated authority to Kasiong cannot be delegated any further. Ang pwede lang po mag-delegate talaga ay yung principal.
And what, therefore, is your concrete basis why you reach the conclusion that Whirlwind is an agent of Lucky South 99?
Well, una-una, Mr. Chair, because that is how Whirlwind explained it to me. And under the circumstance na sila nagpapaupa ng property nila at may interest sila na magkapatuloy ang negosyo ng Lucky South, nakita ko naman po kung ano ang interest din ng Whirlwind. Ang interest ng Whirlwind ay magpatuloy po ang negosyo nung nag-uupa sa kanila, Mr. Chair.
Mr. Chair, I want to go to the basic. Agency is a contract where there are two parties involved, the agent and the principal. It is hard to conceive, Mr. Chair, that Attorney Roque will be relying on the representation only of Whirlwind without an active participation of the other party who is supposed to be the principal, the Lucky South 99. And even assuming that indeed Whirlwind is an agent of Lucky South, I hope we are reminded as well by the principle that the act of the agent is the act of the principal, and the liability of the agent is the liability of the principal. Similar to attorney-client relationship, there is a fiduciary relationship that is existing between the principal and the client. So I wish to conclude, Mr. Chair, that Attorney Roque's representation did not cover only the Whirlwind, but extends even to Lucky South. Mr. Chair.
Okay. Thank you so much. Tama-tama yung time mo. Dahil I was about to... hindi pa ba? I was about to remind you that your time is up. So there is an extension.
Yes,
Another
Mr. Chair.
extension for you, Congresswoman Luistro. Go
Yes,
ahead.
Mr. Chair. I just wish to confirm from the committee, Mr. Chair, if the Bureau of Immigration, the DOLE, and the BIR complied already with our request for submission of records of foreign nationals who were issued working visa, employment certificate, and registration as income taxpayer. That is for BIR. May we hear from them, Mr. Chair?
Yes, BIR complied with all the documents. We have the documents here. I think we have sent it through the Viber group that we created, and at the same time, the immigration also, they have submitted the documents. Unfortunately, ang DOLE, hindi po sila nag-submit. And we did not invite the DOLE, particularly because we have mentioned and manifested in the last hearing that we are focusing on the criminal activities pertaining to the body of the motu proprio. But we will be asking also, but we ask the DOLE to submit all the documents. So, Comsec, can you again remind the DOLE to submit all the documents that being asked by Congresswoman Luistro?
And may I request, Mr. Chair, also our committee to check on the consistency of the records of these three agencies upon submission?
Yes, check nyo ba yung accuracy? Okay, we will be asking the Comsec to check the accuracy of all these documents. And as a matter of fact, all the documents are here at the back of our of the chair. So if you wanted to see the documents and check it for yourself, you can do so. Go ahead, Congresswoman Luistro.
There's a letter here coming from Mayor Capil. May sinasabi po siya ditong sinisiraan daw siya ni Pyra Lucas, Toto Kausing. Allegedly, it is being alleged na mayroon siyang pag-aaring 5 milyon. Nakakatanggap siya ng 5 milyong piso buwan-buwan. Mayroon siyang mga luxurious cars and mansions, which he is denying through this letter. I became curious, Mr. Chair, and may I ask PAOK, kayo po ba ang tamang agency para mag-initiate ng lifestyle check to check on the veracity of the allegations contained on the letter of Mayor Capil?
Hindi po, ma'am. May DILG po na para tumingin po sa kaso niya.
Kung wala naman pong sinabi dun sa substantive law, then the procedural law should not provide. And I do not understand, Mr. Chair, why this should circumvent the law that was passed by Congress, creating the PAGCOR and providing the authorities to regulate all the gaming and gambling activities. I wish to address my question to Attorney Harry Roque. With all due respect, Attorney, Mr. Chair, this is a common knowledge that Attorney Harry Roque worked as the spokesperson for former President Rodrigo Roa Duterte. Does our resource speaker confirm this?
Yes, Madam Chair. Mr. Chair.
And Mr. Chair, can we please direct the resource speaker to describe ano po ba ang trabaho ng isang resource speaker ng Presidente?
As spokesperson, I was addressing the Malacanang Press Corps 3 times a week. I was preparing press releases on behalf of the President, and I was answering queries from the media on behalf of the President.
And will the resource speaker agree if I would say that a spokesperson position is a position of trust and confidence?
Yes, Mr. Chair.
And by position of trust and confidence, it means that the President is giving you his full trust and confidence in all matters that might be within or even relevant to the discharge of your function as presidential spokesperson. Does the resource speaker agree?
Mr. Chairman, subject to regular consultations with the President.
And for the information of the committee, by the position of trust and confidence, it means that the moment the President lost the trust and confidence to the person, he can anytime terminate this official.
I confirm that, Mr. Chairman. I was appointed to a position with the rank of cabinet member.
I understand as well that Attorney Roque is one of the seasoned lawyers, as a matter of fact, internationally. Can you please enlighten us on your background as a lawyer?
I have been teaching international law in UP as well as in American University and National University of Singapore, total of more than 20 years already until now. And I was past president of the Asian Society of International Law. I'm also a member of the List Council of the International Criminal Court.
And having earned that reputation in the legal circle, Mr. Chair, and being the presidential spokesperson as well, I would assume that if ever there will be erroneous decisions on the part of the President, Attorney Harry Roque will be calling the attention and correcting or perhaps stopping the President from pursuing such erroneous action. Will the resource speaker agree to this?
I do not think I had that function. I could only speak for the President. I could not actually countermand him. I could not correct him. He is my principal.
But considering, Mr. Chair, that he is a lawyer and a spokesperson as well, pagka ho ba may maling desisyon ang Presidente, will you not volunteer your legal expertise to correct the President?
Unless I am asked for my opinion, Mr. Chair, I will not volunteer, Your Honor.
Mr. Chair, I wish to invite the attention of Attorney Harry Roque to PD 1869. This is described as the Charter of PAGCOR. And as a matter of fact, it defines what illegal gambling is. I also wish to invite his attention to Republic Act number 9487, which extends the franchise of PAGCOR to another 25 years. Again, it defines what illegal gambling is. Ultimately, Mr. Chair, I wish to invite the attention of Attorney Roque to Executive Order number 13. And I wish to state for the record, Mr. Chair, that for the very first time, the term online gaming was mentioned in Executive Order number 13. This is something which is not mentioned, which is not provided in PD 1869, as well as in RA 9487. May I ask the resource speaker, when the President issued Executive Order number 13, don't you think he legislated?
I am unable to make an opinion because when I was a spokesperson, legal matters such as these are directed to the Presidential Legal Counsel or to the Office of the Solicitor General or to the legal office of the Office of the President under the Executive Secretary.
Mr. Chair, this representation wishes to solicit the opinion of a legal expert, our resource speaker, Attorney Harry Roque. I am sure that with the number of hearings he went through already, he has come across Executive Order number 13. This is the presidential issuance during the time of former President Rodrigo Roa Duterte, mentioning the term online gaming for the very first time. The term that was never mentioned in PD 1869 and even in RA 9487. I hope we can be enlightened by the legal expertise of our resource speaker. When the President issued EO number 13, providing for the term online gaming for the very first time, don't you think, Attorney Roque, that the President legislated?
Again, Your Honor, I am unable to answer because that is not within my expertise. I have mentioned that my expertise is in the field of public international law, having taught and practiced that. And I am sorry because I'm not very familiar with Executive Order number 13. In fact, my only knowledge of Executive Order number 13 was in the last hearing when former Chair Domingo said that President Duterte regulated online gambling, no? Through Executive Order number 13. But I am unable to give an opinion now, not being thoroughly familiar with the EO as well as the underpinnings behind the issuance of Executive Order number 13. I'm so sorry, Your Honor, it's not within my field of expertise.
With all due respect to our resource speaker, Mr. Chair, I find it strange na sa dami po ng hearing na ina-attendan niya, both in the Senate and in the Congress, all pertaining to POGOs, he have not come across EO number 13, from which the POGOs or the online gaming started. But I'm sure for the next concern that I wish to raise, our resource speaker is very much familiar with, because this is fundamental in the study of law. There is in law the principle of separation of powers. And I wish to share the case of Belgica versus Ochoa, GR number 208566, November 19, 2013, on the constitutionality of the Priority Development Assistance Fund. For the information of the Filipino people, I wish to read, the principle of separation of powers refers to the constitutional demarcation of the three fundamental powers of the government. In the celebrated words of Justice Laurel Inangara versus Electoral Commission, it means that the Constitution has blocked out, with deft strokes and in bold lines, allotment of power to the executive, the legislative, and the judicial departments of the government. To the legislative branch of the government through Congress belongs the power to make laws. To the executive branch of the government through the President belongs the power to enforce laws. To the judicial branch of government through the court belongs the power to interpret laws. I wish to go back to Attorney Roque. Attorney Roque, don't you think that the President encroached upon the power of the Congress when he issued Executive Order number 13, providing for online...
Well, Mr. Chair, first and foremost, I argued that case of Bellica. I was lawyer in the Supreme Court for Mr. Bellica, and I confirmed the principle of separation of powers. However, as I said, although it is not my expertise, I will give my opinion, my candid opinion. And that is, under our scheme of things, executive issuances, legislative enactments are all presumed to be constitutional unless proven otherwise. So the status of Executive Order number 13, unless challenged in court, is that it is presumed to be constitutional. Executive orders being in the nature of implementing existing legislation, Your Honors.
Mr. Chair, there's a principle in law. When the law does not provide, we should not provide. When the law does not include, we should not include. If the substantive law creating PAGCOR does not provide for online gaming, then no executive issuances should provide for online gaming. Let us all be reminded by the legal maxim, inclusio unius est exclusio alterius. Kung wala naman pong sinabi dun sa substantive law, then the procedural law should not provide. Let us be reminded that the procedural law should always yield in favor of the substantive law. Mr. Chair, I wish to invite the attention of the committee to Executive Order number 13, the presidential issuance which provides for the very first time for the term online gaming, the term that was never mentioned in the legislation that was passed by Congress. In the 8th whereas clause, it says, clarifying the extent of authority of gambling regulators, particularly with regards to online gaming. And then we have Section 3, clarification on online gambling, which technically defines what online gambling is. And then under Section 4, Mr. Chair, it emphasizes the oversight function of the Office of the President over all forms of gaming, and that includes online gaming. I humbly submit, Mr. Chair, that EO number 13 brings online gambling into life. And I do not understand, Mr. Chair, why this should circumvent the law that was passed by Congress, creating the PAGCOR and providing the authorities to regulate all the gaming and gambling activities. Once again, Mr. Chair, I wish to raise the reason why the principle of separation of powers is very important. The principle of separation of powers and its concepts of autonomy and independence stem from the notion that the powers of the government must be divided to avoid concentration of these powers in any one branch. The division, it is hoped, would avoid any single branch from lording its power over the other branches or the citizenry. To achieve this purpose, the divided power must be wielded by co-equal branches of government that are equally capable of independent action in exercising their respective mandates. Lack of independence would result in the inability of one branch of government to check the arbitrary or self-interest assertions of another or others. To wind up, Mr. Chair, I wish to state for the record that when the President issued Executive Order number 13, it is the humble submission of this representation. He legislated, he amended, he repealed the law, an act which violates the fundamental principle of separation of power. The executive should not encroach upon the power to legislate that belongs exclusively to the Congress. Thank you, Mr. Chair.